Please rise. Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department, or arguments for today, February 27. So please ask for the time that you actually need in order to get out the salient points of your arguments. Please keep in mind that we are fully familiar with your briefs, with your arguments as well. The red light is for you, not for us. If the members of the panel have additional questions to put to you, they will certainly do so. People v. Melvin Santiago. That matter is submitted. 82 Willis versus the City of New York. You want to stand? Were you requesting any time in rebuttal or just the 10 minutes? Okay, so 8 and 8. Matter of M. Children, that matter is submitted. People v. Dalan Joseph.
Request 7 and 2, Your Honor.
625. 13 East 124 LLC v. Taylor. There's no respondent. Oh, there's a respondent. 626. People v. Dory Murphy. That matter is submitted. Morel v. Alisia. 626. Darenberg versus Hyberger. 625. People v. Amat Casmoin. That matter is submitted. S. Klein family versus Defaria. Excuse me. Yes, appellant. Who's appellant? So you did not. You requested time on the reply brief. So how much time are you requesting? 414. Shiron Electrical versus the Office of the Comptroller. Respondent? 625. Arjetta versus 39 West 23rd Street. 624. Heg Belly versus Alisia. 535. Cassie Garage versus New York City Department of Buildings. Matter is submitted. Williams v. New York City Transit Authority. Matter is submitted. J.L. versus the Archdiocese of New York. I'm sorry? 414. First matter for argument, 82 Willis versus the City of New York. There's also a writ on today's calendar as well. First matter for argument is People v. Melvin Santiago. I'm sorry, it's 82 Willis versus the City of New York. Apologies. So you have 4 minutes left out of the 8. He didn't get it.
Good afternoon, Your Honors. It's a 2,500-page record, but there is one page that I noticed when I was preparing.
Only one page out of the 2,500? You made us read all 2,500 and you're telling us that there's only one page we actually have to read?
A picture's worth 1,000
The map.
words. A map.
The map, yes.
This is a highlighted map. Now, this is at page 2157, volume 8. Now, this map, which was put together,
Also
is
at
the
page
vesting map.
25. It's also at page 25 of the record.
I'm sorry, Your Honor, I can't.
It's also at page 25 of the record. Go ahead.
Yes, Your Honor. And this map, which was highlighted by the witness at the deposition, Mr. Schwartz, shows the claimant's property in blue. In yellow, we see the permanent de jure easement that the city acquired in order to build the giant Willis Avenue Bridge. And then in the red cross-hatching, we see what we have referred to as the Willis Avenue extension. This is the only way for someone accessing the claimant's property from Willis Avenue and the public right-of-way is through that cross-hatched area.
So your property was always completely landlocked by lot 62, right?
Subject to access over
Right,
its
you had-
sole access easement, Your Honor.
But the position that you're taking now on appeal, as you seek an award, isn't consistent with the position. Hadn't you been seeking a variance at the Board of Standards and Appeals in which your position was that this was only a de facto temporary taking of the property for which you would not get an award, and it's only now that you're taking the position that there's been a de jure taking for which you would get an award?
Your Honor, the notice of claim clearly shows that it's referencing the de jure taking. The notice of claim doesn't reference a de facto taking, and page 652 of the record shows the page from my appraisal, which was exchanged, I think, in 2014, which basically explains where my appraiser says that
Does the position that you take did the position that you took at the Board of Standards and Appeals, is that something we can consider here in adjudicating this appeal?
well, Your Honor, if you look at my reply brief, I admit that the owner is claiming adequate access now, at least adequate access to develop the property. But that is not inconsistent with my claim. My claim is that as a result of the de jure permanent taking to build a giant bridge and to maintain that bridge into forever, into perpetuity, that the owner was entitled to compensation for the period when it was an exclusive easement during construction.
It was, well.
It was exclusive during
term- the
construction,
de-
Your Honor.
Excuse me, the de jure taking was never exclusive.
Judge, there's no
It's-
case.
it's
a permanent
clear.
easement. It's a permanent easement with all the
Permanent,
rights,
but it was never
and obligations that are attendant with a permanent easement.
And your easement access is still there. You have
The residual, after construction of the bridge, there's access. I mean, we're still encumbered by the flooding problem that resulted that this court threw out in 2019.
Yeah, but you can't assert that flooding problem here. We have a
thrown out.
prior decision on that.
It's thrown out, absolutely. And it's law of the case from Judge Silver that this permanent easement is an unlimited taking. The city made motions to strike the notice of claim, denied. City made motion to give back some of the permanent easement that they took. Why did the city do that? Because they knew they're responsible to pay for the damages caused by the permanent easement. They made that motion to try to take back what they took. And what they did there was they tried to say the footings of the bridge. So just so you know, this easement area, the red hatched area that previously didn't have any bridge in it, now has footings for the bridge in it. It now has a lot of you are professors, right? Real estate rights, middle of the earth, up into the heavens, right? You go into the easement area now, it's got a giant bridge. If there's a problem with the bridge, the city is allowed to access and maintain and fix the bridge over our only access easement. If it happens to block access or be a problem, too bad. The only chance for the claimant to get
But isn't
compensation
the situation that you
today.
both had, that both sides had two non-exclusive easements?
Well, the city had a permanent easement. This concept that it's non-exclusive is the Corporation Council's interpretation of it. It's
so
a
how did they
permanent
take
easement
away-
with all the
so-
rights and obligations that
How
come
do they
along.
take away your easement?
We couldn't access the property for
During the
8 years.
construction?
Yeah, so that's the only claim that's left. We're not
And during
claiming
that period of
lack of
time-
access after that.
During that period of time, wasn't there some arrangement made between the owner or,
And Kiewit Construction, the rogue city contractor that, was constructing a bridge. Yes, Kiewit. So when they were on the lot, the upland, lot 180, there was an eviction proceeding brought, and that was settled in landlord-tenant court, and we basically have a handshake obligation that down the road, any monies recovered in that gun-to-the-head scenario, non-market transaction, then there'll be an offset. But that was, Kiewit paid for the occupancy of the lot. It was, that compensation had nothing to do with the city's obligation to pay for the de jure permanent easement. Again, the city can access that permanent easement area to maintain the bridge forever. My appraiser, our appraiser, when he filed his appraisal, 2014, stated that his damages would be actually $4.3 million, a full take of the property. But because he assumed access would be reestablished at some point, he adopted this lost rent for just the vacant lot, not highest and best use as a multi-residential, but just the vacant lot during construction. It's a very sound claim. It's not difficult. We're dropping the part of the appeal that the lower court threw out regarding, whether our development rights were damaged down the road, so that we had a different after than before under the before and after analysis. So, I think
You're talking about the 88-foot setback.
I'm sorry, Your Honor?
You're talking about the 88-foot setback.
Right, that's gone. We'll drop it. So there were three claims: loss of access, loss of highest and best use, or diminution of highest and best use, and flooding. This court threw out the flooding claim. The lower court has thrown out the highest and best use claim. I'm not appealing it. It's speculative at this point. And we just have a slam dunk loss of access for our sole access area was completely taken over during construction when they were building a giant bridge. It wasn't a rogue contractor that was there illegally. They were building a bridge. They put footings for the bridge in. So it's a very sound claim. And you've seen the cases. Vesting, basically in eminent domain, vesting is at the vesting date. But it was foreseeable, obviously, on the vesting date that during construction, access would be lost. Building a giant bridge. So the site, for the lower court, when it cited to Nichols on eminent domain that damages are fixed at vesting and that subsequent activity doesn't matter, yes, that's technically true, but it's a perversion of what Nichols means by that. Basically, the city had the obligation to provide adequate access at vesting and didn't. That's, as a matter of law, the fact that compensation is at vesting, and that's what all those cases in the briefs are about.
You have time on rebuttal.
I'm sorry, Your Honor.
You have time on rebuttal.
2
Thank
minutes,
you.
please. Okay.
Well, you ceded your rebuttal. Apologies. Yeah. Yes, City?
Good afternoon, Your Honors. The issue to be decided today is whether the city's permanent non-exclusive easement allowed it to block access to appellant's parcel. It simply did not.
Why? I mean, why did it not? You're building a bridge over this property. There is the foot access, et cetera. So why did it not impede the petitioner?
So, Your Honor, the Court of Appeals has held, and in a case cited by both parties in their briefs, the Lake George Associates case, that as long as a condemnee is left with some legal right of access to their parcel, there can be no claim in an eminent domain proceeding for denial of access. And the city's easement here absolutely allowed, the appellant here absolutely retained a legal right of access to its parcel. Through its easement, which was not extinguished, which is a non-exclusive easement. There's no language whatsoever in either the vesting order or the damage and acquisition map that would even suggest that the easement is an exclusive easement that would bar access to appellant's.
Let's say it's permanent, though, right? It says that the city's easement over a portion of lot 62, right, is permanent.
That's correct, Your Honor. There's no dispute that the easement's permanent, but a permanent easement doesn't mean permanent exclusive easement. There are numerous permanent non-exclusive easements. To just give just one example is the easement that appellant has to access its parcel. It is also a permanent easement, even though it's a non-exclusive easement. And courts in New York disfavor exclusive easements. The case law holds that unless there is unequivocal language indicating that an easement is exclusive, courts will deem it non-exclusive. Here, there isn't even equivocal language that would suggest that the city's easement's exclusive, let alone any unequivocal language that would be required. In fact, it's quite telling that appellant has not pointed to a single word in the vesting order or the damage and acquisition map that would even suggest that the easement is exclusive. Instead, their argument relies entirely on the law of the case doctrine, which is based on just a stray out-of-context phrase in Justice Silver's 2010 order denying the city's motion to amend the map. In that motion, the city sought to amend the map to specify the grade of certain easements. It wasn't clear on the map. Ultimately, Justice Silver denied that, basically because there was language saying that the easements ran in, under, and over, and thus they were, when he used the word unlimited.
From 2007 to 2014, their access to to lot 180 was impeded, was it not?
The city denies that, and I think there's a factual dispute there, Your Honor, but the court need not resolve that factual dispute because the issue is whether or not the appellant retained legal access to the property. So appellant, in fact, appellant even said they brought an eviction proceeding. That's exactly the remedy that they would have if someone is interfering with their property. They certainly could also bring a trespass claim. And is there a question, Your Honor?
To be focused here, the appeal has to do with the Willis Avenue motion not being granted with respect to your right to put in evidence and your own appraisal report at trial, correct?
Yes and no.
Isn't that the central issue here?
Well, yes and no, Your Honor, because it's also the central issue of the city's affirmative motion to eliminate to exclude appellant from being able to set forth this denial of access argument, and that's what was granted, and yes, that's what we're arguing about here today. And so, Your Honors, there's if you certainly.
So if you did impede their access between 2007 and 2014, you say they're not entitled to anything, and the reason for that is?
Well, they were entitled at that time to bring an action against the city, whether it was for a trespass or some other relief. They did not. The statute of limitations on that is now expired. If the city tomorrow were to block access to their property, then they would have an action that they can bring against the city to eject the city and presumably seek damages for the trespass. But the only reason, in fact, as the trial court noted in the decision being appealed today, is that appellant had asserted this theory of an inverse condemnation, and the problem with that theory, well, there are two problems with that theory. One is that it was time barred by the time it was asserted, and the second problem is appellants not alleging a permanent ejection from their property, which is a necessary element of an inverse condemnation claim. But that doesn't mean they're left without a remedy, because they still could bring a trespass claim against the city, and they certainly can seek injunctive relief to kick the city out effectively of property where the city is not entitled to be. Now, council made a point about that pillars were built as part of the new bridge. What council's not saying, because he knows it wouldn't be true if he said it, is it doesn't mean those pillars block their access to the property. In fact, from 2019 to November 2022, appellant in 6 separate sworn statements said that they retained a permanent and perpetual easement to their property. Perpetual means uninterrupted. That means they are attesting that they have the same view of this easement as the city has, at least with respect to their proceeding to develop their property.
That's before the standard
That's correct,
board
Your
that
Honor.
my colleague was mentioning earlier.
Yes, Your Honor. The last thing I just want to mention is, council mentioned his appraisal and indicates that it, suggests that it was actually valuing a permanent easement. That's just simply not correct, Your Honors. I encourage the court, if it hasn't already done so, to take a look at the appraisal. It's pages 573 to 750 of the record. One need not read it carefully. Even a cursory review, it's obvious that it's valuing a temporary easement as opposed to a permanent one. One need to only look at the table of contents on page 579 of the record. There are a couple sections devoted to temporary easements, not a single section devoted to a permanent easement. In fact, if you do a word search, the phrase permanent easement does not appear anywhere in the appraisal. There's just one page, page 652 of the record that council mentioned, where there's one paragraph that takes up 1/4 of one page that notes that at the time of the appraisal, they still allege they didn't have access, and the appraiser noted that there's a possibility that access may never be restored, and thus the temporary easement may become a permanent one. But that's just not how permanent easements work, especially not in eminent domain. It's permanent on day one, or it's permanent not at all. And the way you value a permanent easement is you you value it as of the vesting day, regardless of anything that's happened on the ground. Conversely, temporary easements is the one area in eminent domain law where you actually do a retroactive valuation, where you actually look back to see what happened during the temporary easement area. And it's obvious that is what appellant's appraiser is doing in that appraisal, and there's simply there simply would be no admissible evidence at trial that would allow appellant to assert this theory, because there's simply no expert testimony that would support it, and more importantly, no expert testimony or market data that would let the court calculate a reasonable estimate of what those damages would be. And if there's no further questions, thank you, Your Honors.
Thank you both. People v. Dalan, Joseph.
Good afternoon, Your Honors. Siobhan Atkins, volunteer attorney for the Office of the Appellate Defender, on behalf of Appellant Dalan Joseph. The jury here acquitted Mr. Joseph of every single charge for which it was instructed on self-defense. But the trial court refused to charge the jury on self-defense with respect to felony murder count. And upon conviction, the 17-year-old Mr. Joseph...
Are there any cases which state that you can charge justification on a felony murder?
There are no cases yet in New York, but I think that's for a few reasons, Your Honor.
I'm sorry?
I think that's for a few reasons. There are no cases yet in New York, but that's for a few reasons. First is the cases where a felony murder defendant has a viable justification defense, let alone one that is accepted by the jury.
An individual goes into a store with the intent to rob the store, and that individual has a weapon. Say that individual has a knife, right? The storekeeper, in order to protect the property, the storekeeper has a weapon as well. Say it's also a knife. The two engage in a fight, and the defendant, the individual who came into the store with the intent to rob the store, that individual stabs and kills the store owner.
The defendant would not be able to claim the protections of the justification defense.
So how is that different from this instance? So I want to say, I believe we all watched the video in this case, right, of the incident. How, under the facts of this case, where you see the two individuals fighting, where you see the defendant stabbing, or what looks to be punches, but actually turn out to be stabbing motions of the victim, how, under the facts of this case, would a justification charge stand?
Yeah, so just to quickly address your legal hypothetical, and then to turn to the facts of this case, Your Honor. So under your hypothetical, the defendant would not be able to claim the justification defense for a few reasons. One, a defendant has to be protecting himself from unlawful force. And under the penal law, section 3510, protection of property is lawful force. So defendant would not be able to defend against, would not be able to invoke the justification defense under those circumstances. Even if that weren't true, a defendant who is armed in the vast majority of situations is the initial aggressor of deadly force.
And so in this instance, your client, the defendant in this case, was the individual who had the weapon. He had the knife, right?
That's not correct, Your Honor. It was the decedent who pulled out the knife, and here's how we know that. The prosecution's own witness, Ms. Rodriguez, saw the taller man, who is the decedent, holding something in his hand, and the shorter man, my client, struggling to get what it was in his hand. The video shows us what that thing was. It was a knife. The video, when the video starts, it's not my client on top of the other man. It is the decedent on top of my client. The taller, older, he was nearly twice my client's age, bigger man was on top of my client. They are both struggling for control of the knife. At that point, my client appears to stab him a few times while he's on top of him.
Appears to stab him a few times?
Yeah, it's hard to tell. It's dark. But
it was clear to me that that's what was going on.
Yeah, no, well, I think that's all to say, Your Honor, that when The people say that my client stabbed a defenseless man 5 or 6 times.
Well, at that point in time, the deceased had no weapon. The deceased is lying on the ground, and your client is repeatedly stabbing him. And I think at some point in time, if I'm not mistaken, he turns the decedent over and continues to stab him. Then he goes through his pockets, the decedent's pockets, and removes whatever property he removes, and then he leaves.
So just to correct that, Your Honor, again, and I think Your Honor agrees with this, a few of the stabbings appear to take place, as far as we can tell, when the decedent is over him. He does manage to gain control of the knife to defend his own life, and only stabs him once or twice more. All of the stabbings take place within a period of 5 seconds. So to say that there was gratuitous use of force here, force beyond that necessary to defend his own life, is simply not true. And you don't have to take my word for it. The jury here
At the point where the decedent is on his back, he seems to be lifeless, and he's not moving. He's not doing anything. He's not putting up a struggle. He's just lying there, and your client appears to continue to stab him.
all within a period of 5 seconds. And as he explained in his own testimony, the decedent was still threatening him at that point. And
without a weapon in his hand. Now your client has the weapon. The decedent could be saying anything. Your client is the one that has the knife now, and he continues to stab him.
so, I mean, again, he was still defending his own life. And I.
How is he
Why
defending?
couldn't he retreat?
Huh?
At that point, why couldn't he retreat?
Well, I'd like to say just
The decedent is on the ground.
certainly I don't read the people to argue that my client had a duty to retreat that he did not respect. It was a period of fast-moving incident of 5 seconds when all the stabbing occurred. He did not have the opportunity to retreat. And second, you don't have to agree that the jury found justification here. You don't even have to agree that, if you were on the jury, that you would find him justified. All you need to find is that on any reasonable view of the evidence, the jury might have found him justified. And that was certainly the case here, where again, the jury, we have more than that. The jury accepted his justification defense and acquitted him of intentional murder and acquitted him of manslaughter. And
those are two charges which it is clear that a justification charge would be given. There's absolutely no case law wherein a justification charge is given in a felony murder, and it just seems rather absurd to me that a justification charge would ever be given where there's a felony murder. But you do have time on rebuttal.
Can I respond to that briefly, Your Honor?
On a rebuttal, definitely.
May it please the court, Maria Wager for Respondent. I'd like to start off with saying this issue is not preserved. Though it is meritless, it's also not preserved.
Did they request a felony, did they request a justification charge on the felony murder?
There's no proof of that in this record, Your Honor. What is in the record, there's nothing in the record that shows defendant asked for justification on the felony murder charge. There's nothing on this record that shows the court expressly decided that issue in response to a protest. What you have is the court referring, we had a brief conversation in the back, defendant's asking for justification, I'm gonna give it on intentional murder and intentional manslaughter. That's it. What was the conversation in the back? The conversation in the back could be, what charges do you want this for? The conversation in the back could have been, Judge, I agree with you. It doesn't apply.
Counsel, my understanding is that the defense counsel below never objected after the reading of the charges, correct?
Never objected after the reading of the charges, never objected after the instructions or after the verdict was delivered. And I would like to comment on the verdict sheet as well.
In terms of a justification charge being given on a felony murder, are there any cases where that has been done? And would you respond, please, to your friend's arguments as to why, in this particular case, there is a reasonable view of the evidence why one should have, that such a charge should have been given?
Yes, Your Honor, I'm unaware of any case where a defendant's entitled to justification on a felony murder. Justification makes the use of force entirely lawful. But in a felony murder, defendant must be acting in furtherance of an underlying felony. There has to be a causal act that's part of the felonious conduct. So if the force is used in furtherance of felonious conduct, it can't be felonious and entirely lawful at the same time. It doesn't make sense.
Is there any tension between your position and your friend's citation to Penal Law 35, which indicates that the justification defense may be available in, quote, any prosecution of any offense?
Sure. The penal law, section 35, is a very broad brushstroke. And it says that felony murder is available in any prosecution for an offense. And if you look at the definition of offense, offense means, it's not just the penal law offenses. It could be an administrative code case, it could be anything. That doesn't mean you get it. That's like just they intended not to
Well,
limit that.
certainly CPW 2 doesn't get a justification charge.
Exactly, Your Honor. And then the following statutes then limit it. You have to look at 3510, 3515. But in a felony murder, a defendant is strictly liable for the consequence of death. Now, my adversary says that we called it a strict
In other
liability
words, you're committing
offense.
a robbery. If you end up killing someone in the course of that robbery, the killing cannot become justified.
Yeah, correct. And
Does it matter when the robbery occurs? In other words,
the death can't be an afterthought. The death can't be an afterthought. The death has to be in furtherance of the underlying felony, which we have here. But I just would like to
Because as the video shows, the defendant is going through the decedent's pockets after he's finished stabbing him.
that, and there's other evidence. The victim is, helpless at that point. He weakly lifts his head twice as he's rummaging through his pockets. But you also have the cab driver's testimony, and you have the defendant's own words, what his intention was. His intention was to be made whole because he felt he was ripped off, right? And he's saying, well, I wanted a refund. But he didn't have the phone. He already resold the phone. There's no refund where you can't return the merchandise. He intended to take, and here by force and by deadly physical force, and in the furtherance of that, he caused the decedent's death. I just do want to point out the verdict sheet because my adversary is like crystal clear that the jury found him justified, and it's a kind of a wonky verdict sheet, and it is in the record on appeal. If you look at the intentional murder charge, the jury checked off not guilty and wrote an N. And then for felony murder, they checked off guilty and wrote a G. Then for manslaughter and robbery, there's just a check. There's no letter. So what does that mean, that they didn't consider those counts? I mean, the instructions were very
I
confusing.
thought they were told to stop after the felony murder.
Yes, they were told not to deliver any verdicts, but
Right.
there's a difference in how they delivered these verdicts. But at the end of the day, the Court of Appeals has said many times, what may seem like a bizarre verdict is actually just a result of compromise. So to get stuck on, well, the jury believed this witness and didn't believe this witness.
Was an issue raised about that at the conclusion of the trial?
No,
Did defense counsel raise any objection to?
no. Just briefly, if I may, on the sentence, I want to point out that the constitutional claim is also unpreserved, and I don't see any proof in the record that the Attorney General was notified that there is a constitutional challenge. I believe it's as applied challenge to the sentence.
Thank you.
Thank you.
So was the request to charge justification on the felony murder, is that claim preserved?
It is. The CPL makes clear that even if there's a general request, even if defense counsel generally requested justification.
Okay, but the charge is delivered, and there's no objection made to the fact that justification has not been charged for the felony murder.
At that point, the trial judge had made his decision. The CPL, again, the same section, 470.05,
No, but that's not how
subsection 2.
it works, because after the charge is given, the counsel at that point in time would state his or her objection to it.
All the CPL requires is that certainly, there is a way of preserving where you make your position known repeatedly on the record. If the trial judge, however, expressly decides the issue on appeal, that is sufficient to preserve. And that's exactly what happened here. In response to the request to charge on justification, the trial judge made clear what his ruling was, and presumably they discussed it off the record too.
Was there or wasn't there a specific request to charge justification on felony murder?
We do not know what was said off the record, but what we do have is
On
the
the
trial
record,
judge.
On the record, there's no indication of such a request.
What there
that-
is on the record numerous times is a trial judge expressly deciding the issue on appeal, which is that justification categorically in any case is unavailable for felony murder.
Right,
We
and
have
so
that.
at that point in time, counsel should have stated if, in order to preserve it, or if there is in terms of preservation, counsel would say, Judge, we disagree, and we believe, and we're requesting that the justification charge be given as to the felony murder. But I'm sorry, why don't you go
No,
to...
yeah, so I just, even on that, on Your Honor's point, even if Your Honors disagree about preservation, the justification defense is so important that even where defendant's counsel does not request the charge at all, in the people's own cases, oftentimes this court reaches it in the interest of justice. That's the Schwartz case they cite on page 25 of their brief. So that is certainly something we would urge here. But I just want to, if Your Honors would permit, I want to address the point about felony murder and why justification is available in felony murder. Justification does not require that a defendant have unclean hands. It does not require that a defendant have not created the risk that gives rise to somebody ultimately being killed. It anticipates that somebody could initiate ordinary force and yet be entitled to defend themselves from deadly force. So it creates this odd situation where if the people weren't arguing that Mr. Joseph, the 17-year-old Mr. Joseph, were engaging in, albeit wrongful self-help to get his property back, but we're just arguing that Mr. Joseph punched the decedent out of nowhere, he would be entitled to then claim the justification defense when the decedent pulled out a knife.
You know what, it's interesting because I said earlier that it seems absurd, and you know what the people argue, they make an excellent point, is that felony murder to some extent is a strict liability crime, in that if a death occurs as a result of the commission of a felony, then it's felony murder. So how under those circumstances could the action ever, therefore, be justified?
Yeah, so, I mean, I think it's an excellent question, Your Honor, but here's why. Strict liability just has to do with mens rea, right? So it's basically saying that if somebody commits one of the enumerated felonies, we're going to infer that they have the intent to kill from the intent to commit that enumerated felony, right? So that you don't have a defense, for example, saying, I didn't intend to kill. However, McManus, the Court of Appeals case, McManus...
So I didn't have the intent to kill while engaged in the robbery, but I was justified in killing while engaged in the robbery?
So, yes, for example, and we're just
How does that make any sense?
Yeah, so in the vast majority of situations, Your Honor, a defendant would not have a viable justification defense to felony murder. If they show up armed, like in Your Honor's hypothetical, if they come with a knife, if it's an armed robbery, then they are the initial aggressor of deadly force. But in the rare situation where somebody is, again, you know, perhaps the jury could have found that my client threatened the guy to get his property back. He was mad. He was pissed. He, you know, say he pushed him. He threatened him.
So you enter my apartment with the intent to commit a burglary inside. I happen to be there. I confront you because you are entering my apartment, and, you know, I have with me whatever. You pick an object, a knife, a bat, a gun. You take that from me and you kill me.
No.
Then you're justified.
You are not, the defendant would not be entitled to claim the justification defense under those circumstances because a defendant has to be defending himself from unlawful force. And it, under CPL 3510 subsection 6, it is lawful to defend yourself in your own dwelling. So already the justification defense has numerous guardrails to ensure that Your Honor's, understandably, outrageous hypotheticals will not be a situation where a defendant can claim the justification defense. It's only where if someone goes up on the street and punches somebody, that person is not entitled to pull out a gun. They're not entitled to pull out a knife. And then, in turn, the defendant is entitled to defend himself. That's all we're asking for here is a straightforward application of that principle.
Thank you. Thank you both. 13 East 124 LLC v. Taylor.
May it please the court, Nativ Winiarski from the law firm of Cook, Marino, Winiarski, and Bittens. I want to acknowledge from the outset that we do not contest that there is no statute of limitations when it comes to challenging the regulatory status of an apartment, and the tenant in this case was fully within its rights to seek to challenge the deregulatory event that occurred in 2010.
So what I'm struggling with here, Mr. Winiarski, is we know that a vacancy took place in this record in December of 2010 when Amanda Stocker vacated. And then the prior landlord then negotiated a new lease with the successive tenant Hodges for pretty much the same rent, which is about $1,800 recorded as the legal regulated rent, and the preferential rent was about $1,100. We know that as a fact. What I need you to educate me on this, based on the case law, is how are you able to go back retroactively for 13 years and deem a vacancy allowance over that $1,800 legal regulated rent to put it over the $2,000 threshold when the successive tenant to Ms. Stockert was never charged that a higher rent over $2,000 a month, and nor was it ever collected? Because that is the basis for which you are seeking deregulation in your 2023 ejectment action. Am I correct?
You are correct, Your Honor.
So help me out here, because this is not an Altman scenario where Mr. Altman was actually charged over the threshold to bridge the gap. I would like you to give me an appellate case that can help me in understanding your position here.
Okay, well, in the first instance, it's going to be very difficult to educate you, Your Honor, considering your history in regulatory law. But I do refer you back to the Altman case. And in the Altman case, if you look at the language there, it says, in the present case, the 20% increase should have been considered in determining the legal regulated rent at the time of the vacancy. So therefore, as a matter of law, and we know this in terms of when we get into a discussion of whether deregulation or regulation can happen as a matter of waiver, estoppel, or creation, it either exists or it does not. And once you had that vacancy in 2010 and the rent was $1,715, and the landlord was entitled to take that vacancy increase.
But they didn't,
They didn't.
They didn't, so this is the critical thing. When Mr. Altman negotiated the new lease with the landlord then, when he was a subtenant, that new lease was raised to over $2,000 a month. He was actually charged and paid that $2,000 and eventually challenged it, misreading the statute at the time, and many courts misread the statute at the time. What I need to understand is how can you continue to register and charge under the threshold, and then now in 2023, go back and then factor in a vacancy allowance? How can you do that?
So my response to you, Your Honor, is I would hope that we can agree that they were they were entitled to take the vacancy increase, which would have made the apartment deregulated as a matter of law. As a matter of statute, that apartment was deregulated. And that's why this whole issue before the lower court of what rent did they pay or rent did they not pay, it's all irrelevant. Because all that matters is, was that apartment at that time deregulated as a matter of law? And as a matter of law, since the vacancy increase comes into effect as a matter of statute, that apartment becomes deregulated. And that's the critical fact here. And what I want also this court to consider.
So is there a case or anything that states that, that because they could have done so, even though they did not do so, it's still sufficient?
There is no case that's exactly on point. But
Is there anything that's close that suggests that that's correct?
I mean, I would again go to the Altman decision, which again, granted, they specifically took the vacancy increase in that decision, in the Altman case. But it didn't turn on whether they took it or not. If you look at the language in Altman at the Court of Appeals, what the Court of Appeals said, they were entitled to take it. And since they were entitled to take it, that apartment became deregulated as a matter of law.
So under your theory, once they are entitled to take it, then at any point in time down the road, 10 years, 5 years later, 10 years, whatever, they can take it?
Once that apartment became deregulated, irrespective of how it's later treated, it's a deregulated apartment. Had the landlord
Without you doing anything, without you filing any place,
Right, exactly.
without you having a lease executed showing that rent, without telling the tenant that?
as long as the rent is otherwise legal, which we argue that it was, then yes, that apartment becomes deregulated as a matter of law.
And you don't have to file anything.
For the landlord's records to reflect that.
Excuse me?
And all you need is for the landlord's records to reflect that. It doesn't have to be reflected anyplace else.
Well, you have evidence, You have dispositive evidence. What you have here is the registrations were in effect. You would like to have the leases in effect as well, but the leases are only pertinent for purposes of showing whether there was that vacancy. And so while the lower court focused on was the $1,800 reflected in the lease or not, that makes no difference, because what matters, and the reason we had to get those affidavits and find those people in Rhode Island and Florida, was they set forth in their affidavits, yes, these are new tenancies. And since these are new tenancies, and the landlord would be entitled as a matter of law to get these vacancy increases, this apartment becomes deregulated as a matter of law. And that was.
So why didn't you kept, well, I'll move on.
You have time on rebuttal.
Good afternoon, Your Honors. Stephen Heller, Manhattan Legal Services, for the defendant respondent Jessica Taylor. On this appeal, appellant is arguing that the Supreme Court should have determined that this rent-stabilized apartment was deregulated long
What do you
before.
say was appellant's responsibility or obligation in order to effectuate the vacancy or the high rent decontrol in 2010 or 11?
So to
What did he need
effectuate
to
that,
do?
what the landlord would have need to have done on this summary judgment motion was document the legality of every increase above the statutory maximum increases leading up to that deregulation, and to show the rents that were actually charged and paid by the tenants that were in possession pursuant to the leases in effect when those increases were taken.
Well, the landlord provided the affidavits of the tenants, the prior tenants, right? As well as their own books in terms of what the rents were.
They did not provide any of their own books, Your Honor. They provided only the DHCR rent registration history.
Right.
Not a single lease, not a single document showing the performance of IAIs.
No, I don't think there's any, I'm sorry, I don't think there's any dispute that the rent charged and collected from either Ms. Stocker or the successive tenant, and even up to Ms. Taylor up to 2023, exceeded $2,000 a month, correct?
Correct, Your Honor.
So as a matter of fact, it never achieved the high rent threshold, ever.
Ever. And there's also no evidence in the record that there were any rent stabilization riders annexed to the leases. And as Mr. Winiarski has correctly identified, a landlord is barred from correcting rent increases in the absence of those riders unless they can prove that the rent is otherwise lawful. So there is a safe harbor provision that allows a landlord to collect those increases, even absent the riders, if they can document the legality.
You're talking about bridging the gap from a preferential rent to the higher rent. Is that what you mean?
No, Your Honor. So the rent stabilization riders that are supposed to be given on every rent stabilized lease and also to the first tenant after a high rent vacancy deregulation,
Okay.
those riders are intended to give the tenant an explanation of how the legal rent is calculated and an opportunity to challenge that rent and understand that
You
the
have the
rent.
benefit of the high rent decontrol if you haven't actually charged it.
So they would have to document all the rents moving up to that and also show that they had riders in effect, properly tendered rent stabilized leases. Mr. Winiarski and I are in agreement that if they bring it up to the level, under the Altman case, if they bring it up to the level of the vacancy threshold, and then they take their vacancy and that puts it over, they can deregulate at that point. What they can't do is what they've done here, continue registering and giving leases at amounts well below the threshold for the next decade. This court only needs to look back 4 months to its decision in Nadler versus Carmine Limited to understand how this exact set of facts should be adjudicated in light of the court's precedent. In that case, the tenant filed the action. Here it was the landlord seeking to go back 15 years to achieve deregulation. In Nadler, the tenant sought rent overcharge damages and a finding of unlawful deregulation in 2022 to challenge the 2003 deregulation. This deregulation event formulation that appellant is urging was exactly what was adopted by the Supreme Court. They said you can challenge a 2003 deregulation, but you can only go back 4 years more and see what happened in that 4-year period leading up to the deregulation event. This court reversed. They said not only can you review that 2003 deregulation, but as the precedent of this court has found consistently for decades, and as the New York legislature has just recently passed a statute confirming, records of any age or type are reviewable to determine a dispute over regulatory status. So this court said the IAIs that were allegedly performed in 1993 and 1994 are obviously reviewable because those are the increases that exceeded the statutory maximums and led to that deregulation. So the very deregulation event formulation that's being presented to your honors was before you 4 months ago, and you soundly rejected it.
What is the flaw in your friend's argument that the rent guideline board increases were essentially automatic or self-executing, and there was no resort to other, extrinsic proof? These are simply, facts of which we could take notice, that the rent guideline boards for the relevant period in 2010 and 2011 reflected a certain increase to which they were entitled and which would take it over the vacancy, luxury decontrol.
The court also addressed this in Nadler, noted that on the face of every rent registration history is an advisory note from DHCR saying the statements made in this rent registration history are merely the owner's self-reported, unverified statements. The period between 2001 up to the claimed deregulation, the rent more than quadrupled from about $350 a month to over $1,800 a month. So it's not just rent guidelines board renewal increases, it's not just automatic statutory vacancy increases. There's also a temporary exemption claimed in that point where the rent increased beyond the statutory maximums during that exemption, which we have no documentation of whether that was a properly claimed exemption or not. There's 2 vacancy increases taken in a row with no documented tenancy, which raises questions of fraud. We've identified several other indicia of fraud with respect to our rent overcharge claim. But over a 10-year period, the rent contained multiple increases that were not self-executing.
I thought the fraudulent scheme really is addressed to deregulation, not to overcharge.
So, Your Honor, if I may answer.
Please answer that question.
So the deregulation of an apartment permits review of records going back as far as you want. Fraud is another reason why you can review old records, and fraud also affects the base date calculation of rent for an overcharge claim in the way that a deregulation review does not. So the appellant here has cited many cases saying that the 4-year rule strictly applies, and you can't go back any further. And with respect to the deregulation claim, most of those cases are appellate cases, Casey versus White House Estates, Regina Metropolitan itself, Fuentes versus Quick Realty, in which the court actually found that the deregulation was improper and that the 4-year rule consideration came in when reviewing the overcharge. And on the overcharge side, you would need to have a claim of fraud in order to go back more than 4 years and in order to get the base date calculation of your rent done through the DHCR default formula.
Thank you.
Thank you, Your Honors.
So, Justice Schulman and Justice Friedman, I very much appreciate the focus of your attention on whether the 2017, does that vacancy allowance automatically go into effect? But I do note the focus of the argument that was presented, because that was the argument that was presented in the summary judgment motion. The argument that you're raising, that are you entitled automatically to get that increase, that was never brought up below. We made a motion for summary judgment saying this apartment was deregulated. The focus of their argument was that which you heard now. That argument was, well, how do you know that the rent was $1,700 in 2009? What about this increase back in 2002? There had to be an IAI that took the rent from $350 to $900, and based upon that, you can't establish that the rent was $1,700 that would have allowed you.
Well, isn't that, they're arguing that you did not put forth sufficient evidence to show the various increases in the rent.
That's their argument. The argument was not what Justice Schulman and Justice Friedman just presented. That argument wasn't presented in the opposition for motion for summary judgment. And in respect to that, what I'm arguing is, yes, you can go back to 2010 and look at that deregulating event. But what we cannot do, because it would open up the floodgates to tens of thousands of apartments, to say, okay, look at the deregulating event in 2010, but what about what happened in 1984 if there was an increase that hasn't been justified by the landlord? And to that, we know the law in respect to that, right? We have the decision in the Chang versus Westside 309, Justice Hagan, Justice Mendez, you were on that decision. Justice Weber, you were on the Trainer decision where that exact issue was presented, where it was a deregulated apartment. They said, we want to go back and show that the IAIs were improved, and the court didn't allow that. And the reason is rather simple. And it's the argument I presented before the Court of Appeals in Regina versus Metropolitan, which is to say that if the statute says that you have no obligation to keep records for more than 4 years, you cannot penalize an owner for not retaining those records. So in this case, they say, well, what happened in 2002? You don't present those records. Well, the landlord has no obligation to present those records. And so you look at the Quick versus Fuentes decision, also Justice Weber, you were on that one. And you said there's no, that you have no obligation to retain those records. And it's not just a matter of, well, I don't think those IAIs happened. That was Chang versus 309, in which both of you were on that decision. You said there has to be more. And without more, the propriety of the rent was established. And that's why I appreciate very much the arguments raised by Justice Friedman and Justice Schulman. That's not what was presented in the court below. What was presented by the court below was seeking to challenge rents 20 years prior to the deregulated event, and that cannot happen.
Thank you. Thank you both. Morel v. Alisia.
Good afternoon. May it please the court. Melissa Janowski of Morel Lilling Party for the defendant appellants, the Transit Authority defendants. Now in this appeal, plaintiff already agrees that the judgment should be vacated because the clerk erroneously applied the 9% verdict to judgment interest instead of the statutory required 3%. But more than that, there are several bases for why this court should not only vacate the judgment for that issue, but also for a new trial. And that's because the jury erroneously awarded and compensated for pain and suffering and future medical expenses the plaintiff's neck claimed cervical spine injury. The pain and suffering award was excessive, the medical expense award was excessive, and then there's that issue that the verdict sheet should have been itemized with respect to the future medical expenses so that a proper offset could have been calculated to reduce the award.
Well, we have the examinations, the physical examinations of plaintiff, lack of prior symptoms, surgery, observations during surgeries, and then plaintiff's physicians, they opined as to what the future medical expenses would be, and also that the injuries sustained by plaintiff were causally related to the accident. So what was missing?
So that's correct, Your Honor. That was the ultimate opinion of the plaintiff's experts. But the problem with that, with respect to the cervical spine, was that those opinions were conclusory and speculative and failed to address and rebut the defendant's experts' demonstration that not with respect to the shoulder surgery, but with respect to the cervical herniations, that those were degenerative and a product of her congenital condition. Now, the plaintiff's expert at one point, he disputes that it was a congenital fusion. He says it was, instead he calls it a hypoplastic disc. But ultimately, you know, we have our expert radiologist, Dr. Katzman, and this is at page 764 to 767 of the record, really details through his answers to questioning all of the multiple signs that he relied on to form his opinion.
So the jury heard the testimony from the plaintiff's experts, and the jury heard the testimony from your experts, and they made a determination.
That's right, Your Honor, but this is not a classic battle of the experts. There's case law that we cited in our brief, and I know the court knows well, that where the experts' ultimate opinions are conclusory or speculative, a jury's verdict has to be set aside. A jury's verdict cannot be based on that, and that's what we have here. The doctor never provided the explanation for why he concluded that, that her cervical spine herniations were not degenerative.
Well, didn't he testify that while performing the surgery, he looked at the disc and through with a microscope, and he noticed and that it was not degenerative.
That's correct, Your Honor. He did say that. So he said, and that testimony is at the supplemental appendix 82 of the record. He says specifically, he's asked, what did you see during surgery? Did you conclude if it was degenerative or not? And he says, based on what I saw during surgery, it's all caused by the accident because you need to create a trauma in order to exude the disc in that position, in a herniated position. So basically all he's saying is, well, I looked with my 2 eyes and I saw that the disc was herniated and therefore there was trauma. But that doesn't explain why, and he never rebutted. So for example, our doctor said, well, there were no signs of anything like fluid collection or an annular tear, which is an indicator of trauma. Their experts never addressed that, or, other than just saying, well, she claimed she was asymptomatic. So on that basis, we believe that was against the weight of the evidence. But then with regard to how the verdict was excessive, if you look at the other comparable cases, there's nothing about this case that makes it so extraordinary or different from all of those cases that awarded much less than the over 2.15 million awarded in this case. So we contend, if you're looking just at the shoulder injury, the award should be no more than the max is $550,000. Even, like the Bernstein case that plaintiff relies on.
So the verdict comes to more than $3 million. What do you think is an amount which wouldn't be excessive?
That would not be excessive?
Yes.
So for pain and suffering, we would say $550,000 in total. Or if the court is going to include the cervical spine injury, then substantially less. We have the Valentine case was $800,000. Even the Lewis case was $1.5 million. And then with respect to future medical expenses, instead of the $1.2 million that the jury awarded, we believe the only thing that plaintiff proved with reasonable certainty, as the standard requires, was just the medication. So that's limited to.
Well, I thought there was also testimony that she would most likely have to go undergo another surgery.
The doctor said that, right, because of the cervical fusion, that most likely the next level. She testified she didn't want any future surgery.
Well, she didn't want any future surgery, not because she was disputing, according to her, not because she was disputing the need for the same, but she apparently was fearful of even undergoing that surgery in terms of, not making it through the surgery, her family, et cetera. So it's more of a fear of the surgery that she expressed than stating that she didn't need the surgery. She stated that, she was in constant pain.
That's true, that her doctors recommended that they would recommend future surgery. I'll just briefly, that doesn't prove with reasonable certainty because she was wavering on the surgery. It's not reasonably certain she'll undergo it because she said she was fearful to do so.
Thank you.
Good afternoon, Your Honors. May it please the Court, Travis Wong for the plaintiff respondent, Ms. Morel. As far as the causation of the cervical spine, plaintiff's doctor did opine that it was caused. He observed it. His opinion is based on the facts, his treatment of the plaintiff, and his medical expertise. So in no way is it speculative or conclusory. Additionally, with respect
Well, she did have some type of genetic or...
She did. That
it was fused, right?
Yeah, well, Dr. Avanesov, through an MRI, testified that it wasn't congenitally fused, that it was actually a hypoplastic disc, and he specifically opined that the hypoplastic disc did not cause the herniation. And as far as a defendant's contention that their expert was unrebutted, that's not true. He testified that there were bone spurs which indicated degeneration. Our doctor testified that bone spurs were necessarily an indication of degeneration, and he further testified that it was that fusion that caused the herniation, and our doctor testified there was no fusion. And in any event, even if it wasn't unrebutted, the jury does not have to accept any of the testimony of defendant's expert. It is their right to give it the weight they should accord it, be that some or none at all.
My understanding on the record is that the future medical expenses, that number, the $1.2 million, came from the testimony of your experts, correct?
That is correct, Doctor.
And the jury tend to just go with the numbers offered. They didn't have a counter number for that.
I'm
The
sorry.
jury
Didn't have
generally would take the number offered by the plaintiff's experts as to the cost.
Yes, yes. So the jury accepted the number set forth by plaintiff's expert.
I don't recall, was there any countering number for the values that were presented?
I don't believe so. No. So the numbers I believe are on page 80 through 88 of the record. There were no counter numbers, and as far as the pain and suffering, those were not excessive. Plaintiff had a cervical fusion, a shoulder injury, both of which resulted in permanent loss of range of motion, permanent muscle weakness, to which her doctors opined and which she testified. I know defendants make some argument as to plaintiff engaging in symptom amplification. However, that is only an opinion of defendant's doctors, which again,
Well, I think one of the doctors said that when she came into the examining room, she was able to remove her clothing, she was able to remove the neck brace, she was able to remove whatever shoes or boots or whatever she had on
and again, that would go.
without any difficulty.
Yeah, so that goes to the weight of the evidence. Plaintiff herself testified that she struggles to put on her clothes, that her sisters have to help her, even though they also have to.
Right, but she did not employ any type of aid or anything like that. She relies totally upon her family.
Yes, she relies on her family, which one does when
She's not paying though.
The medical future expenses don't include home health care. So even if she intends to continue to rely on her family, that is just for her medication, the injections, and the pain management treatment that Dr. Rafman recommends, with the
Possibility of a future surgery.
Yes, with the possibility of future surgery, which Dr. Avanesov testifies she will need. And as you said, she didn't say she won't get it. She just said she's fearful of getting a surgery right now and would like to continue with conservative treatment, and which is exactly what happened with the first surgery. She was
To satisfy your burden of establishing the future medicals with reasonable certainty, did you have to offer some testimony by the plaintiff that she would in fact have the surgery if it was necessary? Or is it speculative whether she would undergo that surgery even if a physician was strongly encouraging her to have it?
Well, I think it's based on the medical need, and whether she'll or not. The doctor, there's evidence from the doctor that it will be necessary in the future, which is sufficient to meet plaintiff's burden for the medical expenses.
Did your friend below offer a jury charge to the extent that your client would be unwilling to ever take that surgery?
So did he offer a jury charge? No, I don't believe that was discussed at the time of trial. And I would just like to quickly address defendant's argument with respect to insurance law 5108A. There's no case law supporting their contention that the workers' compensation fee should be applied to all future medical costs for the plaintiff. That would be completely speculative and as to what costs she will incur. It would inhibit her ability to choose her own medical providers. And if you have no further questions, I will rest on my brief.
Thank you.
Thank you.
I have just a few quick points in rebuttal. One, with respect to the excessiveness of the pain and suffering award, none of the cases that plaintiff cites in their brief come close to being compared to the plaintiff here. She lost 1 day of work, she went right back to work, there were no fractures, she didn't have any complications from the procedures that she did undergo. So, with that in mind, we urge the court to reduce. With respect to the medical expenses, it's not true that it's enough for a doctor to just say this treatment is necessary. In order for the plaintiff to met their burden, you have to show that it's necessary and reasonably certain to be incurred. It has to be a cost that's reasonably certain to be incurred. And it was not, a lot of these, for example, there's upper extremity nerve conduction tests, these injections, all of these treatments, some of which she hadn't, she discontinued years prior, that their testimony was that she may consider them. And even the plaintiff's counsel in his summation It says, you know, these are just, we're not suggesting she's going to have all of these. These are just different things she may consider and try.
So as one of my colleague asked, did you put in any alternative numbers at all?
No, Your Honor, and it's not our burden to do so. The plaintiff ultimately has the burden to prove, and it's our contention. They only proved at most the medications because that's what she was currently undergoing. And then just with respect to the insurance law issue briefly, there's no case law saying it does apply specifically, but there's also no case law saying it does not apply in this context. And what we do have is the clear statutory language and the PJI. There's the PJI 2:285A expressly provides for this type of scenario, and that the jury should have been given a itemized verdict. So for that reason, there's two issues there. Our motion in limine should have been granted, limiting plaintiff to only claiming those amounts under the workers' compensation schedule. And second, having denied that motion in limine, the verdict should have been itemized.
Thank you.
Thank you for your time.
Sternberg v. Hyberger.
May it please the court, Keith Silverstein for the appellant, Seth Denenberg. On this appeal, Your Honors, it's neither fact-intensive nor law-intensive. The issue on this appeal is the interpretation of a simple stipulation that resolved a very simple motion to compel. In their motion, the respondents claimed that the appellant had failed to fully and completely respond to a notice for discovery and inspection. As a question of law, this court need not give any deference to the trial court in its interpretation of the stipulation. The stipulation, which appears at page A196 of the record, is in a standard format. The first whereas clause identifies that the motion that is being resolved, that is the subject of the agreement. In this case, it was respondent's motion to compel in connection with very specific notice for discovery and inspection. There were several enumerated items that were being demanded. The second whereas clause identifies the appellant's position, which was that he had produced all of the documents in his possession that were responsive to the notice for discovery and inspection. The parties then state the condition of their agreement. The respondents withdrew their motion.
As things now stand, you are precluded from introducing the the partnership agreement, right?
That's correct, Your Honor. That is correct. And that would be an unjust result, Your Honor. And if I could make...
So that would make it impossible to prove your case.
It would make it impossible. The issue is prejudice. In their argument, the respondents do not argue in their brief and do not argue at the trial court that they were prejudiced or that these documents, I'm sorry, they do argue that they were prejudiced, but they do not argue that these documents were responsive to any request for production that had been served. They do not argue that we breached the stipulation by falsely claiming that documents had been produced that we withheld. Why? Because they were not. The exhibits which we attempted to introduce, or which we would like to introduce at trial, were not documents that were requested by the respondents or by the defendants. Instead, what the respondents have argued to support this far-reaching, overbroad interpretation of the stipulation is that it was written, and I quote from page 25 and 26 of their brief, protection for the defendants so that plaintiff would not attempt any last-minute improper document submission. What would constitute an improper document submission? They continue in their argument. In the next sentence, they state, the defendants needed this assurance before withdrawing their motion, a motion to compel with respect to specific document requests, to ensure they would not be prejudiced as they prepare for the trial and the action. What would constitute prejudice? In this instance, in this case, Your Honors, prejudice would be plaintiffs attempting to introduce a document that they withheld that should have been produced in response to that
And
specific.
so this is a document which arguably they would also be in possession of.
Oh, they are absolutely in possession of it, Your Honor. It's correspondence between the parties. It's the partnership agreement. It's the referee's determination, which was the subject of the dispute. There's no surprise. And I think that's the issue, is that
Well, I think Supreme Court, it wasn't so much that they were not already in possession of the documents, it was more so that they were unaware that you would be attempting to introduce the documents in trial.
respectfully, with deference to the trial court, nobody knows from one side or the other what documents are going to be listed on your exhibit list until you do disclose your exhibit list. It's the litigant's responsibility to make demands. You can make a demand. There was not even a demand on the notice for discovery and inspection, which is any document that you intend to produce at trial. That did not appear. That is a broad, overreaching request that as a trial attorney, I am obligated to respond to. That would have been a better argument in front of this panel than to simply say, we were prejudiced because the respondent didn't make the request. Your Honors, the plaintiff complied with the notice for discovery and inspection. They properly responded. And then when Judge Crane took that one statement out of context and applied it to every document, she misinterpreted the...
Well, the stipulation does say any documents within plaintiff's possession or custody which have not been produced in discovery may not be used by plaintiff at trial, presented at trial, or in any way referred to or alluded during the trial. This was the language in the stipulation. It seems to be unambiguous.
You're correct, Your Honor. The language that is the language. It is unambiguous, but that would defeat the purpose, the setup, the context, stipulations like...
So essentially, if the partnership agreement was led in evidence and your witness list was not challenged, you're able to bring the witnesses that you want. That issue has not been appealed, just the document issue. And you're home free, right?
That is the...
I'm saying, if the partnership agreement is offered into evidence and your witnesses get to testify, whatever as your case in chief, you're okay.
Then we have a case, Your Honors.
Okay.
Thank you.
Thank you.
May it please the court, my name is George Sava for the respondent. Most of the arguments
So
that...
what justification is there for precluding the appellant from introducing any document which it's established that you have in your possession, regardless of whether they produce it?
Well, Your Honor, it's not established that it was in my possession.
You don't have the partnership agreement? Your clients
You have to
don't
understand.
the partnership agreement?
Well, hold on, Your Honor, you have to understand. Just because they produce a document claiming that that's the partnership agreement doesn't mean it is the partnership agreement. There were numerous failures throughout this litigation by counsel, by the appellant, where precluded us from getting documents.
There's a letter that your client sent to him. They want to introduce that at trial. They didn't produce this in discovery saying, oh, we have this document, here it is. But the letter comes from you. Why shouldn't they be allowed to produce that? Why shouldn't they be permitted to introduce that letter at trial?
Well, Your Honor, I think it's important to understand that because of what they did, we never had an opportunity to even enter into depositions with the parties. There were so many failures by them, we never received it, and we ultimately were entitled.
We're talking about documents now. The letter comes from your client to them.
It does.
To him.
But Your Honor, it's the four corners of the document. It's really the four corners of the document.
It's your letter.
I withdrew a motion to strike their pleading. In that, I demanded, and we negotiated, that if they didn't produce it, it wouldn't come in.
What Supreme Court is going to preclude is within the discretion of Supreme Court, is it not? And what we're going to uphold is within the discretion of this court.
But look at the chilling effect that would have on any trials, Your Honor. What that would mean is that any party could withhold any document, never raise it.
Why shouldn't the letter which you wrote, why should they not be permitted to introduce the letter which, I don't mean you, but your client wrote?
Because, Your Honor, they agree that they wouldn't. And let's be clear. We never had an opportunity to depose them because there are many failures. I mean, the lower court went ad nauseum through all the failures. So I didn't want any surprises, and I wanted to know what they were going to put in since I didn't have an opportunity to depose or get the thoughts process on any of those documents.
Counsel, can I ask you something? Mr. Dennenberg was terminated as a partner based on the partnership agreement, correct?
Correct.
And you were relying on an express provision of the partnership agreement to have terminated him, correct?
Correct.
That probably will be your defense to any claim he wants in terms of reimbursement of his investment, right? So why, as I'm sitting here, it's the agreement that you both worked on and signed, and you're relying on the very document to justify your position in terminating this partnership. Why? Where's the prejudice?
Your Honor, the prejudice comes from an agreement. Are we going to adhere to the four corners of an agreement? Does that not matter anymore?
When you mention the agreement, you're talking about the stipulation or the partnership agreement?
I'm talking about the stipulation is the contract. A stipulation is a contract between the parties, and it was very clear. They had an opportunity to say, anything we produce or anything in your possession. They chose not to do it. Moreover, they had a full
So by
month.
saying that anything in your possession, which you agree that you do have the partnership agreement in your possession, right?
No, in their possession, Your Honor.
In your possession, do you have the partnership agreement?
I have a copy of a partnership agreement. I don't know if it conforms with what they're trying to put into the trial.
Has that ever been modified, changed, or?
I don't know, because quite honestly, Your Honor, once I saw what they put in, I didn't even address it. I immediately made my motion in limine because I only had a short period of time to do that.
So to follow up on my colleague's point, so you need, you would have to produce an question as to the partnership agreement as well in order to sustain your case, would you not?
I'm not sustaining the case. I'm defending.
Well, excuse me, in order to defend your case, you need the partnership agreement because that's the agreement under which he was terminated and which he's requesting money.
I wouldn't need to defend it because it wouldn't be coming in at all, so I wouldn't even need to address it. But I think what's important here is I think the court is looking at this in terms of general practice rules, okay?
So again, your
That's
position
not what this is.
Your position is the stipulation clearly states that plaintiff is precluded from introducing or speaking of any document which they have not produced to you, right?
Because the public, unless it's a violation of public policy, parties are allowed to set any rules that they want within the litigation. We set the rule. They agreed to the rule. We withdrew our motion.
So you're making a lot of good points, and I heard you mention this a couple times, how the stipulation is a contract, and I think we all would agree with that. So there's a principle of contract law that a de minimis breach of a contract does not give rise to a claim for breach. So if a partnership agreement was in your possession, how wouldn't the failure on their part to turn over the partnership agreement be nothing more than a de minimis breach of this stipulation?
But that's different, Your Honor, because the failure to provide it means we couldn't actually discuss it, verify it. What's its veracity? Was it the actual partnership agreement? Did we have the opportunity to question? We didn't waive that. That was taken away from us based on the failures of the appellant. Moreover, counsel had a month from the time we executed that stipulation before they chose to file their note of issue. They could have supplemented the discovery. They chose not to.
I'm sorry, Justice Weber, just one follow-up.
Yeah.
Do you recall, I know there was extensive reference in the plaintiff's complaint to the putative, and in deference to you, the putative partnership agreement. Do you remember if a copy of that partnership agreement was attached to that complaint as an exhibit?
It was not.
Okay.
At least I'm not aware of. Moreover, the record here before the court, although you're referencing the letters and all that, counsel never put in those documents into the appendix. So I don't know, I mean, we're referencing documents that is not part of the appendix. I put them in under my motion, but I redacted all of that. So one, our position is anything that they're trying to get in, we did ask for in our discovery demands. The other aspect is their arguments are outside of the record because they never even put this in before you. The court, unless the court goes back and subpoenas all the documents from the lower court, but the lower court judge, Justice Crane, looked at this, same arguments, and found them lacking. And the last point I'll make, and I'll sit down, is that what would this mean? that if council's now able to just, let's throw the stip away in the provisions of that. I threw away my opportunity to move for, to strike their pleadings due to this, but that doesn't matter anymore because that's out. That anybody could withhold any document and wait until the moment of trial, bring it out and say it was in their possession. I think that would have a chilling effect on trial procedure. And I think that's why Justice Crane was right with what she did, and it should be upheld.
Thank you.
Thank you very much. I'm compelled to correct some issues.
Well, I do see that the documents referred to were an appendix to respondents' papers.
Yeah, as far as the question about the partnership agreement, it was referred to, and in fact, it was objected to because there was a claim that the partnership agreement was confidential and that we had breached that confidentiality by even referencing or quoting it in the complaint. So there was a specific reason not to attach it to the complaint. Second point, the defendants never requested the depositions, and so counsel's come up and said, we didn't have a chance to take the plaintiff's deposition. They never requested it. Second, the four corners of the document. The stipulation, we can look at the four corners of the document, which says that the plaintiff's position is that they have produced all responsive documents in response to defendant's request for production. That's the setup. There is no tsunami of stipulations that are going to be overturned. This was an articulate, well-crafted stipulation addressing a very specific motion and plaintiff's responses to the notice for discovery and
Okay, so in
inspection.
the stipulation, plaintiff represented that he had produced all responsive documents that were within his possession, custody, or control in response to defendant's discovery request.
Correct.
So did you produce the partnership agreement as well as the respective letters?
They were never requested.
So don't we have to give meaning to all portions of the stipulation? And so would we be reading out then that central sentence that Justice Weber referenced earlier, that any document within plaintiff's possession or custody which have not been produced in discovery may not be used by the plaintiff at
No.
trial, ...
We are literally, the appellant is asking this court to read the document in its entirety. Justice Crane looked at one sentence. We're asking this court to look at the entire stipulation to interpret the sentence that Justice Crane took. In fact, one of the issues that we had in preparing the appendix, and I apologize if I may answer the question, one of the issues that we had in preparing our appendix in that we had to file a motion to supplement was that the actual stipulation was never attached to the motion in limine, which Justice Crane arguably had in front of her when she was interpreting it. She was literally just looking at the motion and that one sentence. So we had to file a motion to supplement the appendix to include the actual stipulation.
So again, your position is that because the stipulation states produced all responsive documents in response to discovery demands, they never requested the partnership agreement or the letters in their discovery demands, and so therefore those documents are outside of the second part of the stipulation.
that
Any
is correct.
documents within plaintiff's possession or custody which have not been produced in discovery?
Exactly, Your Honor, 100%. And last point.
That was the last point. Thank you very much. Thank you both.
Thank you.
No, you're not, but thank you. The next case for argument is S. Klein Family v. Defaria. Help me. Deratafia?
Yep.
Oh, very good. Thank you, Justice Mendez, and you. Like a linguist. Yes.
Good afternoon, Your Honors. May it please the court. The guarantor in this case guaranteed the obligations of the tenant under the lease, and the tenant was Genius Preparatory Services. That's the only entity that was listed as a tenant in the lease, and that's the only entity who the guarantor's obligations or who the guarantor was guaranteeing the obligations of. And in any personal guarantee case, the crux of the case is whose
Well,
obligation.
let's look at the four corners of the guarantee.
Yes, Your Honor.
The guarantee shall remain and continue in full force and effect and shall not be discharged in whole or in part, notwithstanding any alteration, renewal, extension, modification, amendment, or assignment of, or subletting, concession, franchising, licensing, or permitting under the lease. So we have a modification, a later modification, do we not?
There is a modification.
So therefore, under the guarantee, under the four corners of the document, why is the guarantee still not remaining and continue in full force and effect?
So first, the guarantee states that it's any modification of an agreement between the tenant and the landlord. The subsequent lease modification in 2019 was not an agreement between the tenant as defined under the 2000.
It says under the lease. It doesn't say specific parties.
Under the lease. And under the lease, the tenant is Genius Preparatory Services.
It also says subletting, though. Subletting, concession, franchising, licensing, or permitting under the lease.
Correct, Your Honor. And at summary judgment at this point, there is no facts in the record that show or state that there was a sublet or an assignment or anything like that. There's simply
But what is undisputed is Mr. Defaria, I hope I'm pronouncing the name correctly, the guarantor,
Yes, Your Honor.
signed both the original lease on behalf of GPS, and he signed the lease modification on behalf of GPS and UST, correct? And we have case law that says when you have the same personal guarantor signing two successive documents as done here, then he knowingly signed it, knowing it as a lease modification, agreeing to the original terms and conditions that are read into the modification. So the guarantee that he signed still remains extant.
Your Honor, that would apply to if our argument was that he didn't receive notice, right? So he had signed the lease modification, and so we can't then come to the court and say, well, as the guarantor, he never received notice of the modification.
No, but I'm going beyond that, not notice. He signed it. He signed both. The second lease just adds another tenant and just raises the rent, but basically the same terms and conditions. It's like a renewal.
But it doesn't add another tenant, and there's actually ambiguity even in Appellate's brief as to whether it adds another tenant or changes the actual tenant. The lease modification says that the tenant, not tenants, the tenant is Genius Preparatory Services and Union Square Tutoring LLC as tenant, singular. So it changes the actual party that is the tenant.
And your argument is because it changes the actual tenant, therefore it's not a modification or a renewal, that it's a new lease agreement?
Not that it's a new lease agreement, but you have to look at it under the context of analyzing.
Well, if it's not a modification, it's not a renewal, doesn't it therefore have to be a new lease agreement? Then what is it?
If we're looking at it in terms of plain contract law, comparing the 2017 and the 2019 agreements, yes, you could say, we're not conceding, but yes, the argument could be made that it is a modification. But analyzing it under the standard of personal guarantees, where you have to give all inferences in favor to the personal guarantor, changing the party completely changes his obligation.
But the point is that if in fact it is a modification, then the guarantee survives.
I understand the point, Your Honor, but
You have time on rebuttal.
thank you, Your Honor.
Good afternoon. May it please the court, Cheryl Ginsburg for the plaintiff respondent. As Your Honors correctly pointed out, the guarantee in this case explicitly said that it's binding as to lease renewals and modifications, and the case law in this department has repeatedly held that a guarantee such as this, in the cases 250 West 78th Valdez, 35th Street Associates versus Sasson, remains binding as to extensions. The fact that the tenant, there was an additional tenant in the lease extension does not change that. Actually, the guarantee at paragraph 2, in addition to saying that the guarantee remains in full force and effect as to extensions, also explicitly says that for purposes of the guarantee, tenant shall be deemed to include anyone doing business in the premises. So the fact that there is an additional tenant does not matter. And the tenant did not change fully. There was an additional tenant. There are two separate signature lines.
Isn't the argument that the guarantor it wasn't his intent to guarantee this new tenant? It was only his intent to guarantee the former tenant?
Well, either way, he's still guaranteeing the former tenant. The former tenant is remaining liable, is still the tenant under the lease. The former tenant still owes the money.
But
under
he's
the
now
original
also
lease.
liable for the new tenant, right?
Well, either way, the guarantee says that he remains liable for the new tenant because it says he remains liable for any occupant clearly in that extension. And he signed both signature lines for both tenants on that lease extension agreement. There are two separate signature lines for him there.
I mean, if the original lease didn't remain in effect, the provisions in the lease modification agreement, which refer back to the original lease, would become meaningless.
I don't see why that would be. I think that
No, but if the original lease is not deemed to remain in effect, notwithstanding the lease modification agreement, when the lease modification agreement refers back to the original lease, if you say that lease doesn't exist anymore, that would make that lease meaningless.
Well, the lease was deemed to remain in effect.
It wasn't a hostile question.
Okay. I'm saying the lease modification agreement was clearly a lease.
Refers back to the original lease, indicating that the original lease remains in effect.
Right.
So the response is yes.
Yes, because in multiple places, I think there are 5 different paragraphs where it's referencing the original lease. It's saying that the lease remains in full force effect, is only modified in these in these scenarios and otherwise remains in effect. It says it's supplementing these provisions. It references the security deposit. The lease modification agreement would not make sense at all if it wasn't a modification and if it was a lease, if it was a new lease as opposed to a modification.
Thank you.
Thank you.
Thank you, Your Honors. Briefly, just to clarify, the point there that he would then be liable for the obligations of anybody that then takes over that space is exactly, I think, the scenario that courts are trying to prevent when they say that the main point of a personal obligation is whose obligation you're actually obligating. The obligation, the guarantee, the way it's written would then, yes, it would obligate him to any tenant in the space for, eternity, which is obviously
Couldn't the guarantor voluntarily enter into such a transaction? It would be up to the guarantor to bargain for a limited definition of tenant?
And there is a limited definition of tenant here. It does say if there's an assignment, a sublet, and whatnot. But again, at summary judgment, there's no facts in the record that say that any of that took place. You simply have a different tenant, a different party. There wasn't a party that was added. Under the plain terms of the lease modification, there's a totally new tenant.
Thank you.
Thank you, Your Honors.
Shiron Electrical v. Office of the Comptroller.
Good afternoon, Your Honor. May it please the court, Laurent Drogan from Tartar-Krinsky and Drogan. The appeal in this case asks the court to examine the line between evidence and substantial evidence and the difference between inferences and reasonable inferences. And at stake here is the continued existence of a minority-owned electrical contractor who in 26 years of service to New York City had a spotless record. It now faces 5-year debarment from public work. That public work consisted of 80% of its business. It's the extremity of the penalty that warrants a careful examination of the evidence here. The evidence must be substantial because of the draconian penalty imposed by this statute, 5 years of debarment. We look to the New York Court of Appeals 1978 case in 300 Gramerton Avenue Associates versus the State Division of Human Rights to understand the difference between evidence and substantial evidence. Substantial evidence requires the examination of the record as a whole, the weighing of the quality and the quantity of the proof.
So the investigator and for the comptroller's office spoke to, the investigator here spoke to the 2 employees who were involved, also spoke to, I guess, your client as well, and another employee. As to issues as to how they were paid, issues as to the training, et cetera. So why was that insufficient?
Well, we're not saying that the problem here is that the investigation itself was insufficient per se. It's that when it got up to the trial level, the evidence that was actually presented by the controller and
Right, so why did it not, why was it not substantial evidence? Why was there not substantial evidence based upon what was told to the investigator by these employees, the lack of records also kept by your client?
Well, the lack of records doesn't prove anything other than they didn't have records for a certain period of time. It doesn't answer the question as to...
Well, during the period before March 2017, he paid the particular employees in cash, left them off the certified payroll records, did not maintain the required wage and hours records for them required by the labor law.
And the reason for that is because our position was they weren't doing public work. They were warehouse workers who on occasion were making deliveries to job sites. So they would not have appeared on the
So you don't have to pay them, you could pay them in cash?
I can pay them cash, but I wasn't required to pay them the prevailing wage if they're not doing prevailing wage work.
So, but you could pay them in cash, and also you did not have to keep any records as to their wage and hours?
I do under a different section of the New York labor law that's not an issue here. It's outside the scope of this record. This is specifically Section 220. This is specifically certified payrolls for prevailing wage work done on a prevailing wage job. If I have, hypothetically, undocumented workers working in a warehouse and I'm paying them sub-minimum wage in cash, terrible thing, violation of a labor law, but not the issue in this case.
But the oath, this was an oath hearing, correct?
It was.
And the two employees in question got to testify.
They did.
So, and in weighing credibility, that was what the oath job was, correct?
It was.
And their testimony was that they were doing prevailing wage work. They weren't limited to just warehouse work. Their testimony was that they were pursuant to 2 public works contracts. They were in the schools, in the kitchen, doing electrical work working alongside your other electricians, correct?
That's the evidence, and here's
That's
why
the evidence.
And here's why it's not substantial. It's not substantial because when the case was presented, what is the proof to corroborate that you were actually there? Well, one of them said, I was given an alias to use, and when I would sign in, I would use that alias. So they
So he signed in as Gurpreet Singh, right?
I'm sorry?
He had Gurpreet Singh. Well, part of the evidence is there's a sign-in sheet bearing the signature of Gurpreet Singh, right?
That's one of them.
Right, which Hardwinder says, I signed that.
He did.
So if that's true, that's happening at the school, right? That's not happening at the warehouse.
Yes. And
So how do you refute that when you seek to say that there's not substantial evidence?
well, I go back and I say, and this goes back to the investigator who didn't bother to find out whether there was a Gurpreet Singh, which there was, and he later admitted. He never contacted Gurpreet Singh.
Well, what would have stopped you? What would have stopped you from producing Gurpreet Singh and saying, no, that's my signature and I'm Gurpreet?
Nothing would have stopped me from doing that if I had the burden to prove a negative. They had the burden to prove a positive.
True, but they presented this as positive evidence of the fact that they weren't being paid prevailing wages, that you used invalid IDs and had them signing someone else's name on a sign-in sheet. So if the hearing officer believes that testimony, that's substantial evidence, not by itself, but in the context of all the other evidence.
But that's the key. You say not by itself, and that's exactly what we're saying. That was the only evidence. 2 people, they didn't even cross-corroborate each other. So can it be that one person can stand up and say, I worked on this job?
And I worked at the school, and I did
school.
electrical work at the school,
and
I didn't get paid prevailing wages.
But I signed
Why
in
isn't that evidence?
Because I signed in using an alias, and there are 16,000 pages.
Corroborative of what they're testifying to when you produce the sign-in sheet, which is signed by someone else, which Hardwinder says, that's my signature. So you're saying, well, that evidence is not true. But the hearing officer believed that evidence, and you didn't do anything to refute that evidence at the hearing.
It's not a matter of refuting it or not. And the other individual, the alias never appeared on a sign-in sheet. So it actually, he testified, I used an alias. It never appeared in over 16,000 sheets. 14 of them went into evidence. It didn't appear once. And there is a Gurpreet Singh. The investigator testified, we weren't sure whether there was a Gurpreet Singh. There was in the certified payrolls, there was a Gurpreet Singh. He never contacted them. So this was his testimony. That testimony, I never contacted Gurpreet Singh. I never contacted the supervisor that they presented. I never did this, I never did that. That's what he admitted he did. So all you have standing alone, literally alone, are two guys saying, I worked on a public jobs site. Period.
The lack of records. You have time on rebuttal.
Good afternoon, Your Honors. May it please the Court. Jennifer Lerner on behalf of Respondent, Office of the Comptroller.
So what was the substantial evidence?
Exactly what my adversary just talked about. There was a live testimony from two witnesses who testified as to the work they did, working at the schools and performing prevailing wage work as assistant electricians. And my adversary's theory that there needed to be more or there needed to be corroboration of live witness testimony is just not supported by the law. The ALJ here frankly said this turned on the relative credibility of the witnesses. And with the opportunity to observe their live testimony and demeanor, she found those witnesses, both Shiron and Hyberger, credible about the work they did, how it worked in terms of the schools, that they went to the warehouse in the morning, picked up their tools, went to the different schools, and did electrician work. So to say that that's not substantial evidence, I mean, more is not required. The substantial evidence—
Your point is that the testimony is the substantial evidence, and the response to it is that, well, there's no document substantiation, there's no hard evidence other than the testimony supporting it. But your position remains that testimony is evidence.
Absolutely. Absolutely, Your Honor. And the role of the ALJ at oath was to weigh that testimony, weigh the other evidence, listen to the witnesses, and determine who was to be believed here. And the ALJ found both of the former employees credible as to the work they did, and found the witnesses for Shiron incredible, and found their testimony vague. And that's what it largely comes down to. I mean, it's well and good to criticize the investigator, but you know, the investigator present BLL, the Bureau of Labor Law, responsible for enforcing the prevailing wage laws, put on testimony. And so there was a full hearing over 4 days to weigh that evidence. You know, my adversary said that it's substantial evidence because of the harsh penalty. But substantial evidence is because there was—
The 5-year bar is mandated by statute.
Exactly. And it's harsh penalties because these laws are notoriously hard to enforce. You can look at the legislative history for the rule, for the law, and that's why it's there, to encourage strict compliance with these laws. So, you know, there is substantial evidence here. While this court certainly reviews the determination, the law is clear that where there's a credibility contest, even if the court would have ruled differently, it's not the court's role to reweigh the evidence and substitute its view. As to willfulness, all that is required is that the employer knew or should have known about that they were supposed to pay the prevailing wage laws, and that was certainly found here. Once it's determined that they were indeed doing prevailing wage work, that supports the willfulness determination. I mean, as to the sign-in sheets and the aliases and fake IDs, the ALJ and the controller didn't even need to reach that to make the determination. The ALJ said it was limited corroboration. The other 16,000 that my adversary is referring to, they weren't in the record. We don't know what they said. You can't say one way or the other. What was in the record was the testimony of one of the witnesses that 2 of the signatures of Gurpreet Singh were his. So it's limited support for his testimony about the work. Lastly, on the calculation, the law is very clear that in order to make sure that the employer doesn't unfairly benefit from their failure to keep records and to pay the prevailing wage, and it is under labor law section 195.4, even for non-prevailing wage work, as they claim they were performing, they are required to keep records, payroll records, of the hours worked and the rates of pay and gross and net wages. They requested that in 2017. The hearing was in 2021. They never produced anything showing this. And so if they had that, it might support their argument that they were warehouse workers or doing other work. They were unable to do so. So for all these reasons, we ask that you confirm.
Thank you.
Thank you.
The law really isn't hard to enforce at all if one person can come up and say, this is where I was and this is what I was doing. Thank you. We have to weigh the evidence. In order to weigh the evidence, you have to look at all of the evidence. So you do have to look at cases where substantial evidence has been examined. The Third Department in Mid-Hudson versus Hartnett talked about persistent investigative work that produced live witnesses who corroborated that the individuals on certain payroll were reports on job sites. They didn't present a single witness. These two guys couldn't even corroborate each other. They did nothing. They stood two guys up on Zoom, and they simply had them say, I worked on job sites.
I'm sorry. I'm sorry. I'm trying to understand something. The controller's office started a proceeding against you.
Yes.
Correct? And they investigated, and you were in a hearing, and you had principals of your client testify, correct?
Yes.
So your client had a full and fair opportunity to present a case to show the legality of everything you've been advocating here. You had that ability to do that.
The only question was, were these individuals
and there was
on
a
job
claim
sites?
that you submitted falsified records, among other things. So they're weighing it. So the burden was on you to show that everything was kosher.
The only question is...
And the oath judge determined that it wasn't.
The only question is whether they were on those job sites, and the only evidence to support that, the only evidence was each person said, I was there. They didn't even corroborate each other. All of this other evidence...
Counsel, what other evidence would they submit to prove that they were at those job sites?
Well, the investigator could have spoken to the supervisor who was identified. They could have brought in other people who were on the certified payrolls or the sign-in sheets.
Who did the supervisor work for?
It worked for the company.
What company?
Shiron.
And so could you not have brought in the supervisor to say that that was untrue?
This was 5 years later. I imagine if he was around...
The investigator could have done so, but the individual who worked for you as a supervisor, you did not do so.
The difference is we didn't have the burden of proof. And when you look at...
If you analogize it to a prima facie case situation, by producing the testimony of these employees, you've created your prima facie case. So you're saying that's not good enough, but you aren't precluded from bringing in your witnesses to say, hey, those witnesses aren't telling the truth. This is what happened.
But this is essentially like directed verdict, right? If you simply...
No, it's not, because you had an opportunity which you did not wish to take advantage of. You said you're going to remain silent, or you're going to just put in certain evidence. But you had, as my colleagues have stated, you had a full...
There is evidence in the record. The employer did. All three witnesses denied it, and I recognize the court was then free to decide who they could believe.
Not free. That was what the court's job was at that point in time. But thank you both. Argueta versus 39 West 23rd.
May I begin, Your Honors? May it please the court. We ask that this court reverse the grant of summary judgment to the plaintiff on his labor law 240 parens 1 claim because triable issues of fact exist. We submit that the plaintiff failed to prove what safety device, if any, should have been provided, or what safety device.
So is there anything that says, is there any case law or anything that states that he has to show exactly what the safety device was, which was required?
Not necessarily, Your Honor, but if you read the case, and I don't mean any disrespect, in reading the case law submitted in the brief, in Walensky alone, summary judgment was granted to plaintiff by the trial court, reversed by the First Department, and affirmed by the Court of Appeals because tribal issues of fact existed as to what safety device should have been provided. There was pipes that were standing up during a demolition project, and when demolition was taking place elsewhere, those pipes fell on the plaintiff. And the record, the Court of Appeals affirmed that there was no proof as to what safety device, if any, should have been provided.
Well, you could have, in opposition, put in testimony or an affidavit that those posts that were leaning at the time were in the process of being loaded onto the truck, but you didn't do that. So we were left with, from the plaintiff's point of view, very large poles used for the cement work that were not secured. And when his back was turned, one fell on him.
Well, I have 2 points to make.
And so that's a gravity-related injury.
Sorry, Judge.
That's okay.
In response to your question, those posts were posts that were used during the concrete curing process. That day, plaintiff and his coworkers were charged with collecting all of the leftover posts from floors 24 to 20, putting them in a cart, putting them in an elevator, bringing them down to the ground floor, putting them on a ramp, and bringing them to the tractor trailer that was there to pick them up. So they were in the process of collecting the leftovers and bringing them there. Plaintiff testified that there was 3 trips. They brought the carts down without issue. On the 4th trip, he saw that there was posts that were leaning against that flatbed truck. Prior to that 4th trip, he said, I saw 2 guys on the truck putting those posts up. We submit what should have held those up if the very point of the work that day was to get those shores off this job site and onto that truck. In other words, why are you going to hold up these posts if the whole point was to get them off the site?
Why lean them against the truck in a vertical position and not in a horizontal position on the ground?
That question's not answered, Judge. That's a great question. That's a tribal issue of fact for the fact finder we submit to decide. We submit those posts were on the ground level. Plaintiff is on the ground floor. He's working on his knees. He's not doing work at a height. Nobody's doing work at a height, and that's how we distinguish the cases that were in the decision. There's no work taking place.
So you're saying that the fact that the poles are standing in a vertical position and tip over, that is irrelevant?
Judge, I'm not saying it's irrelevant. What I'm saying is here, we don't even know why they tipped. There's no evidence as to why they tipped, how long they were staying there, what they weighed. Tribal issues of fact exist. Were they 30 to 50 pounds?
Why is it a tribal issue of fact? The fact remains that they did, in fact, tip. They fell on top of the plaintiff.
Well, because nothing was holding them.
Right. And in Walensky, in that case, the question was whether there should have been some kind of ropes or harnesses or the exact type of, there was a dispute as to what type of safety device should have been used. Here, you're stating that no safety device should have been used.
The incident report cited by the respondent at record 651 says that it was an improper storage and handling of materials.
Yes.
There's no mention of a gravity-related risk or of a height. This could fall within the ambit of 241.6 rather than 241.
Plaintiff testified that they fell on him, that they were elevated, as my colleague stated, they were leaned against something, and then they fell onto him, gravity-related.
The incident report says that they slid. Not that they fell, that they slid. And the incident report also says it's unknown why it could have been a vibration. In a similar case we cite, which is qualified.
Does it matter why it slipped? I mean, if it's a vibration, if you needed a safety device, would that matter?
I guess, Your Honor, we submit what safety device should have been used. That's what I'm saying plaintiff's burden was, to show what safety device should have been used or what could have prevented that accident when he's working at ground
It
level.
doesn't matter whether it's a slip or whether they fell. The fact is it's gravity-related, the way they are up against the wall, and then they fall on him. Gravity-related.
So I'm reading the report from Castro at 639 of the record, and he says the post was being loaded onto the truck. The post was in the street, leaning against the edge of the flatbed section of the truck when suddenly the post just fell, striking Oscar in the back. That's at 6:39. Rodolfo Castro. That's his witness statement. So he saw what happened. He saw that the pole just fell. He didn't say it slid. He didn't say someone tipped it over. He said just fell.
Well, the site safety manager puts in his safety report that it slid, so there's another.
But he wasn't
challenge to
there.
the fact, Judge.
The site safety manager wasn't there.
Right.
Castro was.
And you rely on the site safety manager's report, which is hearsay, in terms of the, whether it was 30 pounds, whether they weighed 30 pounds, whether they weighed
40, 50.
50 pounds or more, which again is irrelevant in terms of the weight, because again, we have them leaning against the wall and then falling on top of the plaintiff. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the Court, Jonathan Moran, Grave and Associates for Plaintiff Respondent. As I believe it is clear from the record, this unsecured heavy metal post that was leaning against a flatbed truck fell.
What safety device should have been used here?
Well, I would submit to Your Honors that, as has been pointed out here, that it's not my burden, the plaintiff's burden, excuse me, to submit on a motion for summary judgment what safety device could have been used. However, you could have had someone holding it, you could have had a cart, you could have had straps, you could have laid it down horizontally on the ground and had somebody handing them up. There is no testimony or affirmation from an expert saying that doing so would have been contrary to the objective here. And I would submit that this is really no different than the case recently decided by this panel, Mejia v. 770 Broadway Owner LLC, in which a scaffold pole, which was part of a scaffold that I believe was being disassembled, was standing vertically on its end, left unattended, and fell over, striking a plaintiff, and due to the effects of gravity. And here you have a similar situation where a pole, which was capable of being extended to 11 feet high, fell over, whether it was due to vibration or wind, it doesn't matter. The effect of gravity caused this pole to fall over and strike my client. That is a prima facie demonstration of a violation of the statute. And in response, the burden shifted to the defendants to show that some safety device would have been contrary to the work being performed. That's not on this record.
Would it matter what the weight of the pole was?
I would submit, Your Honor, it doesn't, given the fact that this was a large, heavy metal pole where it's clear that it was not of a de minimis, where the height could not be de minimis given the nature of the object that falls.
Well, your client testified that it was 9 to 11 feet long and weighed approximately 150 pounds. The site manager's accident report states that individuals opined that the post weighed between 30 to 50 pounds. And so your friend in their arguments state that this shows that there are issues of fact, at least it goes to the credibility of your client.
I would submit to Your Honors that under either version, whether this court is inclined to accept 30 to 50, 150, take your pick, under either version of events, there's still a violation of the statute, as we know from Sanchez v. One Burgess Road and many other cases from this department. A lack of certainty as to what preceded an accident, where it does not go to a material fact to the happening of the accident, does not present a bona fide question of credibility regarding the plaintiff. And this was also not an unwitnessed accident. There are consistent statements in this record with some minor variance, but very minor variance, that this pole fell over and struck the plaintiff. There really is no question as to what happened here.
Thank you.
Thank you, Your Honors.
Judge, once again, I submit there's nothing in this record, even just now, counsel answering, saying what safety device could have saved could have prevented this accident. And I just want to cite to Fabrizi, I'm sorry if I said that wrong, Fabrizi versus 1095 Ave of the Americas, 22 NY 3rd, 658, 2014 case. To prevail on 240 parens 1, plaintiff must demonstrate the existence of a hazard contemplated under the statute and the failure to use or the inadequacy of a safety device of the kind enumerated thereunder. So we just submit to you, Judge, I'm not asking for summary judgment dismissing the claim. Plaintiff was granted summary judgment affirmatively. I'm asking that this court reverse that grant of partial summary judgment to the plaintiff and allow the jury to decide whether or not the statute was violated. If your honors have any other questions, I'm happy to answer them. I know it's been a long afternoon, so.
Thank you.
Thank you very much.
Heg Belly versus Olescu.
Good afternoon, Your Honors. I'm Jeffrey Hellerman. I represent Eugenia Heg Belly in this medical malpractice action, which claims the defendants negligently failed to diagnose ovarian cancer. This case involves whether the trial court erred in not appointing a temporary administrator for the estate of Dr. Serban Kochoba, MD. Again, this is our cross motion was for a temporary administrator, meaning that the administration of this estate would end at the end of this action, whether by settlement or judgment. It doesn't go any further than that. And furthermore, in this action, the estate of the defendant Kochoba, the estate and...
But you commenced the action after the doctor had passed away.
That's correct.
So you were aware of the fact that he was deceased.
That's correct. And that is consistent with a fairly recent case of Franco versus the state of Kettera, where the second department allowed the appointment of a temporary administrator, even though the action was commenced after the defendant was deceased. So it's similar to that case.
So you recognize that from the inception of this action, when you're dealing with an estate and an executor without more, that there was no jurisdiction over the entity, the estate, right?
Well, we did not sue the individual Dr. Serban Kochoba, MD. We sued the estate of Serban I. Kochoba, MD, and Ariella built
And the wife as executor.
Right. Exactly. And she, as her own affidavit states, there was no will, and she was the surviving spouse at time of death.
But the estate at that time was not a legal entity.
Yes, that's correct. And then we asked the court to appoint Ms. Kochoba as the temporary administrator, with the estate limited to the insurance policy in question. And
You're saying that you wanted Supreme Court to issue an order substituting the individual or naming an administrator?
Well, right. Well,
but under what precedent or statute would the court allow that?
Or authority.
Or authority.
Well, again, the 2023 case of Franco, state of Kettera.
But isn't that case different because there the public administrator had already been appointed by surrogate's court as a temporary administrator, so it was just extending it to another case, but for the same deceased?
Yes, it was, but it was a different case though.
But the public administrator had already been named as the executor for the estate.
Yes.
So, there could have been a different outcome. I mean, it was not a foregone conclusion that the wife would in fact be named executor of the estate. I mean, when you go to surrogate's court, the letters could have been issued to another entity, another individual.
But based on the affidavit of Ms. Kochoba in this case, there are no other individuals. She doesn't say there are any individuals.
Yeah, but that would be a determination to be made by surrogate's court based upon the proper procedure before surrogate's court.
But going back to the Harding case in this department in 1989, the Supreme Court is a court of general jurisdiction that can appoint a temporary administrator.
Yeah, but as you probably know, Supreme Court normally defers to surrogate's court under these circumstances.
But in this case, assuming...
Since I was surrogate here for a while, I kind of know that. The Supreme Court was always deferring cases to surrogates court.
But the issue is, I've seen this in other cases where the issue gets bounced back and forth between surrogates and Supreme, and there are cases where they're.
Well, not so much here, but counsel, you still have recourse. You can still go to surrogates court and have surrogates court make a determination.
But the problem is that pursuant to Surrogates Court Procedure Act 1112, a public administrator can't be appointed if there's a surviving, if there's a survivor.
Right, but we don't know that the public administrator would be appointed.
Well, based on the public administrator law in SCPA 1112, a public administrator can't be appointed because Ms. Kopa is the surviving spouse. And if we go back into surrogates court, she's going to put in another affidavit saying the same thing. I don't want to be the administrator. And
maybe the public administrator will end up getting appointed.
Yeah.
But that wouldn't be allowed because Mrs. Kopa is alive and she is the surviving spouse.
A determination. Somebody would have to be named as the administrator, and so. That's a determination for surrogates court, but that's not really something that is for us to decide. What we are faced with is whether or not Supreme Court properly denied your application. You have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honor. Stephen DiBraccio, Wilson Elser for the defendants' respondents. Your Honors, boiled down to one sentence, the issue in this case is not whether Supreme Court had the authority to appoint a temporary administrator, but whether it properly exercised its discretion in failing to do so. As Your Honor pointed out in the Franco case, there was a petition already filed in surrogates court in Franco. Plaintiff's counsel references the Harding case. There, the case
was ongoing already.
I'm sorry, Your Honor?
Harding, the case was an ongoing case.
Yes, Your Honor.
It wasn't a situation where you're starting a case with a deceased defendant.
Precisely, Your Honor. In Harding, the case was trial ready, and the decision was made to avoid prejudice to the scheduling of the trial to do that. Here, as the record indicates at page 314, plaintiff has not even served a bill of particulars yet. Pleadings have been filed, and that's where we are. Plaintiff also references the Venarthos case in his reply brief, and I want to clarify, and there's some distinctions there as well. Again, in Venarthos, first of all, the decision mainly focused on whether Wilson Elser was to be disqualified for an adverse relationship with a co-defendant. And that, in Venarthos, a co-defendant challenged whether the trial court could appoint Wilson Elser as the administrator. And additionally,
that was an issue of standing.
It also was an issue of standing as well. That was the first basis for affirming the decision. And also, and again, to my point, the note of issue had already been filed in Venarthos as well. Here again, minimal discovery. To the presiding justice's point during plaintiff's argument, plaintiff references in his reply brief that extensive efforts were made to appoint defendant Aurelia Kosioba. Plaintiff's efforts amount to she was served with service of process and she was served with a motion for default judgment, which was later resolved. Plaintiff could have gone to surrogates court and filed a petition there. I acknowledge that there might be a case where by delays out of plaintiff's control in surrogates court or for some other reason that the discretion might be, given that it's trial ready, it might be a proper case. Plaintiff did not address this at all in his opposition in below or his cross motion. One last point on this, it came up during plaintiff's argument. Plaintiff argued in his reply brief that defendants claim that Mrs. Aurelia Kosioba is not the proper person to be appointed administrator. Defendants never made that argument. They didn't make that argument before the trial court.
That there is no one other than her, right? And she did not want to proceed with it. I'm sorry, I believe he stated that she categorically stated that she did not wish to be appointed. Did he not say that?
I I don't recall that specific language. She submitted an affidavit saying that she was not appointed and
was not
never
appointed.
sought to be appointed. But in any event, my point is, defendant's argument is not who should be appointed administrator. The point is, whoever it is, that should be determined in surrogate's court.
Yes.
Plaintiff did not address the motion to dismiss the defendants filed, and I'll just say very briefly on that. Plaintiff sued a non-entity, the estate, and plaintiff sued Mrs. Koshoba, who is not the administrator, so she's not a proper defendant. Plaintiff did not address this in his argument, but for the reasons in our brief and the decision below, defendant's motion to dismiss was properly granted. If there are no further questions.
Thank you.
Thank you.
Briefly, just on the case itself, we have submitted a bill of particulars in the plaintiff's deposition, actually was held with the other defendant. But in this matter, there's nothing in any of the case law that says that the Supreme Court must defer to the surrogate's court. They have concurrent jurisdiction.
Yes, but again, there has to be some showing, I think, that there is some unusual circumstance or something that is unique and specific about the particular case which would warrant the Supreme Court to do what you're asking Supreme Court to do. And I don't think that you presented anything in your arguments in support of that. What is unusual, like was mentioned, there was ongoing litigation in another case, or ongoing litigation in that particular case, which if there was not that appointment, it would somehow delay the proceedings. There was no showing made here.
Well, the estate of Kokochoba's attorneys participated in discovery and produced an insurance policy that they said covered Dr. Kokochoba's care, and that was not disclaimed. So the estate in this case is only the medical malpractice insurance policy, and that's clearly an issue that's dealt with almost exclusively in Supreme Court. Surrogate's court doesn't handle medical malpractice.
But you're only going to surrogate's court in order for there to be the appointment of the administrator or the executor. I mean, that's the only thing that surrogate's court is going to do, and then the matter will proceed in Supreme Court, will it not?
Yeah, but in this case, the motion was made in February 2024, and it wasn't until a year later that it was decided. And during that entire time, this issue was under the jurisdiction of the Supreme Court. And we're not going to, then we'd be going into surrogate's court while the motion is pending, having two different judges decide the same issue.
Well, your action isn't dismissed. You still have a claim against the medical practice and another doctor.
The medical practice, as mentioned in the...
I understand that the decedent was the chief cook and bottle washer here, but you still have a claim against another doctor here. The case isn't dismissed.
We do have a claim
All
against
you
the
need
other
to do is the action gets stayed, you go to surrogate's court, you can explain and seek an expedited process, and just get an administrator and you'll be back in the saddle.
Thank you. Thank you both.
Thank you.
JL versus Archdiocese of New York.
Good afternoon. First of all, I'd like to thank you for granting our request for permission to argue. May it please the court, Patrick Lawless for the defendant appellant, Archdiocese of New York. Forcing the Archdiocese to disclose the names and other identifying information with respect to claimants who participated in the confidential IRCP program, first of all, it violates New York's longstanding public policy when it...
The IRC specifically states that the Archdiocese may in fact disclose the name of that claimant to law enforcement as well as to the district attorney's office. So those individuals are on notice that their information may be disclosed to others. So I did not understand your arguments as to confidentiality.
Well, it's still going to be remain confidential. That is not unmasking him in a civil litigation. That's required pursuant to statutory reporting requirements.
Yes.
And that's still going to remain confidential within law enforcement. But it's a different context here where you have the potential for claimants who are promised confidentiality by the Archdiocese, who are going to be bombarded with private investigators from plaintiffs, who knows when they're going to be showing up at their place of work or at their home, who may not want to disclose, wanted this information disclosed.
But they were.
It's a big difference.
My point was they were aware that this information was going to be disclosed, albeit, they're told that it's going to be to law enforcement and to the district attorney's office and other law enforcement agencies, but they're already aware of this. And, it's really speculative that they're going to be bombarded by investigators, et cetera.
But I believe it still violates New York's public policy when it comes to confidentiality. And it's, ironically, it's a case cited by the court below and the plaintiff, Harmon, which actually supports keeping this information redacted. The name of the case is Harmon, and in Harmon, there were two sets of documents that contained information regarding other alleged victims. The first set, which the court ordered disclosed.
I just want to be sure, we're talking about disclosing the names of people who are other victims of...
Other alleged victims.
Thank you, yes, other alleged victims of the same alleged perpetrator.
Correct, but they participated in the IRCP program, which was a confidential program. And not only do the IRCP documents say that this information is going to be kept confidential apart from the statutory reporting requirements, there's an authorization where the participants would sign saying they want their information to remain confidential. And in Harmon, there was a similar program run by the Archdiocese of Albany, which the court in Harmon said that information should be redacted.
I thought the third department rejected your argument and stated that the information was subject to disclosure, so long as the plaintiff shows a substantial need for it and is unable to obtain its substantial equivalent.
In Harmon, though, the mediation program documents, the court said should remain redacted. There were other documents would have had a group of different individuals that voluntarily spoke to a private investigator that were contained in a private investigator's report, and that's what the court said could be disclosed. But it said the mediation program that was instituted by the Archdiocese of Albany, those victims' names remained confidential and redacted.
Thank you.
Thank you.
Good afternoon. May it please the court. I'm Diane Palicelli, and I represent the plaintiff J.L., and I also want to thank the court for giving us the opportunity briefly to respond. It's, as Judge Krause rightly decided below, entirely speculative to say that these victims of this same abuser would not want to help others. Entirely speculative. There was no promise of confidentiality, and we lay this out in our papers. But I want to jump straight to Harmon because I want to address what Mr. Lawless just said. In Harmon, the court recognized, the trial court recognized the need of the plaintiff for this very important information. What could be more important than victims who are notice witnesses? That it was very important, and in that case, they allowed a list of victims of the abuser to be disclosed. Now, in addition to that, there was requests for IMAP, a little bit different, or maybe it's a little bit the same as IRCP for up in Albany, and they allowed the discovery of priests who were not even the priest at issue in the case who abused the plaintiff. Yes, there was that the trial judge did say that there should be some sort of recognition of the privacy interests of those, and there were a lot of victims in that case, but not the ones that the plaintiff had gotten from the personnel file of the victim. So the court there recognized that the plaintiff had information, had these victims' names, and it was sufficient, and in controlling discovery, the trial court in its discretion can decide
That's the bottom line. We're talking about discovery. We're not talking about evidence at trial. Right now,
Absolutely.
we're just talking about discovery. We're talking about information to be provided to the plaintiff so that the plaintiff can perhaps, investigate, find other witnesses, gather other information. We're not talking about evidence at trial, admissibility.
Absolutely, and it's discovery, anything material and necessary to the preparation of the case. Justice Krause determined that this was, and correctly so, material and necessary to the prosecution. And let me say, there's not going to be bombarding of these individuals. There's a confidentiality order that keeps things confidential just for the purposes of litigation. We're officers of the court. Certainly, the investigations will be done in a proper manner. No plaintiff, no victim is.
Well, you do understand the concern, though.
Of course.
You share the Archdiocese's concerns that, these victims will be bombarded and that they will be harassed, right?
Well, Your Honor,
You just want to ensure that that's not going to occur.
There's a balancing that needs to be done, and that is what Justice Krause, in her role as the trial judge overseeing discovery, that's what she did. She looked at the needs of the plaintiff and balanced it with, the disruption to the Archdiocese and whatever concerns there are for other victims. And she was entirely within her discretion to do that, and the Archdiocese has not shown any basis to overturn that at all. I'll say something just in addition to that. What Judge Krause did was follow this court's precedent in McNerney. McNerney did concern IRCP documents, despite the comments in the reply. That was part of the numbers of things that the plaintiff was asking. And there in McNerney, this court said that documents and information that may go not just to prior notice, but also to obtaining information that will assist with direct proofs, cross-examination, and rebuttal. And as we laid out in our papers, there are numbers of issues that the Archdiocese itself raised in its answer, such as it did not control this priest, that it did not control the high school.
Thank you very much.
Thank you very much, Your Honor.
Just very briefly, first of all, McNerney didn't involve this specific issue, which is the disclosure of the names of other alleged victims. I would know because I argued the McNerney case before this court. The other issue is about all these claims about control and modus operandi. First of all, and as with the other information that the plaintiffs claim that they may be able to garner from disclosing the names of other alleged victims, plaintiffs haven't shown, as is their burden, that they can't obtain this information from other less onerous means. And the issue of control and first of all, modus operandi is a criminal concept that doesn't really apply here because we know who the alleged abuser is. The issue of control can be gleaned through other means. They have the alleged perpetrator's entire personnel file. They have the names of the people that he worked with. There are other means to get this information that are less onerous and less potentially harmful.
Thank you.
Thank you.
Thank you both.